Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on fire. Time for a girl on fire. Time for a
Hello, no, I'm muted. I apologize. I never have to close my other computer, but I did because I could see myself. Okay, Crimson is here. It is Vicky's birthday today. We owe her a happy birthday and a song. Reseller is here on time. Casey Carey is here. You guys, what a day already. What a day, what a day, what a day. Hold on, as I was doing something on my computer, but I can't. I hope that everybody's had a wonderful day. Vicky's here, Vicky's there. Vicky's there. We're going to sing happy birthday to Vicky. Then we'll talk a little bit, but let's just start that. So happy birthday to you, happy birthday to you, happy birthday dear Vicky P. Happy birthday to you. Thank you so much for all of your support, Vicky. Always, I love waking up to your lovely comments in the morning. They're very, very supportive, and I thank you so much. I hope you had a wonderful day and that your birthday dreams come true. Hi, Sabertail. We are celebrating a birthday of our friend in here. We like to celebrate birthdays around here. If I could, I would bake you a cake, Miss Vicky. And we would all share in it, aka I would eat it all. Hey, Christopher, what a day, baby! Now, this is going to take forever to show up on the screen. Chris has sent $2. Ooh, he makes me scream. Yay! Thank you so much, Chris. I don't know why it's going to take so long. I'm a little bit nervous from yesterday's situation with the memberships, but I so appreciate you. Seriously, what a day. What a day. First of all, it's been rain. Yay! This heart's too big for me to fit it in my little hands. I do have little hands, though. I've been told that. They're little. They're little. Seriously, I am so glad, Vicky. Of course, I'm glad that it was your birthday. I'm glad you spent it with friends. And I'm glad that we're here together to watch Judge Grumpy Bromlick in his element get grumpier and grumpier by the minute. I mean, he puts even me up for a, Oh! Casey Carey, look at that. Wow. First of all, thank you. Ah! You guys are, oh my God, Vince, get your little hands on what? You're amazing. First of all, we got a jackpot, got a membership. That's hilarious. We're going to love that. We love that that's working again. So Casey Carey, thank you so much. We got a jackpot. Welcome. That's Creed, in case you guys don't know. And then Vince, how long is it going to take Streamlabs to put up that amazing super chat? I hope your dog wasn't hurting you when he was attacking you. Amazing, amazing, amazing. Seriously, Streamlabs, put the big heart up. Put the big heart up. What if Paul's thing... Look, Paul is going to push it through. Has anybody ever told you you'd done that, Paul? You just pushed it through. But you didn't. Look at that. We're still waiting, Streamlabs. Vince was so kind. The very least you could do is put it up on the screen. Oh my gosh. I'm so embarrassed. It's like when you when you're like in charge of a kid and they don't say thank you for a really long time and you have to tell them like 57 times. You're like, say thank you, Paisley. Streamlabs, say thank you. I said, say thank you. Bill, you're hilarious. Grim, push, super chat, push it. I push it. I push it. Ah! No, it's still not. Streamlabs, what the fuck? I'm embarrassed. Streamlabs is late on the uptake. I'll put it that way. Late on the uptake. Better on some other things though, Paul. Like, certain parts are good, certain parts aren't. Anyways, thank you guys so... Oh! Woo! Woo! Get my little hands on this. I'll put my little hands on something. Thank you so much, Vince. Seriously, love it. Love you. Let's go ahead and get on. Oh, Christopher Angleby, thank you. You have a great night too. Oh. Did you have crumble cookies today again, Chris? I'm jealous. I'm jealous every time you say time for crumble cookies. Yeah, just Streamlabs check somebody's balance first, right? Oh, look at Mr. Checkmark strolling in. Oh, look, Mikey, Streamlabs equalizes you. Yay, Bev! Streamlabs equalizes you, Mikey, because they don't give you a check mark if you notice. But Mikey is Mr. Checkmark in the chat. Guess who got a membership today, Mikey? We got a jackpot. Amazing. But Cindy's right. Let's get these people divorced, Paisley. Enough fucking chat. Enough chit-chat, lady. Enough chit-chat for that. Where is it? Oh my god, I record too much court. I'm a hoarder. I'm a court hoarder. Has anybody ever accused you of being a court hoarder, Brian Thompson? Also, this is going to be an interesting divorce because it seems like these people have money. These people have money. Now, $2 from Mikey. Thank you so much. First of all, appreciate it. It's going to take about 10 minutes for that to come through. And then, NPC, did you just say check my pee-pee? I would love to. That's my favorite thing to do. Let me get this playing, and then I will. But thank you to Mikey and to NPC. You guys are amazing. 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 Loud. Yes, that is an NPC. That is a OG. Sorry, now I'm getting all the acronyms mixed up. I think that is an OG. 7 months. Almost? 8 months? Let me get this playing. No, okay, Crimson. Also, these people, first of all, I just want to say this judge, he is always, check your pee-pee, no kink shaming. Oh, gosh. Okay, let's go.
Matter, Angela Younglove versus Paul Younglove.
For the record, this matters before the court for continued pretrial conference subsequent to mediation. This hearing is being conducted via Zoom. Present is Attorney Leah Rourke, representing the plaintiff Angela Younglove. Ms. Younglove appears to be present with Ms. Rourke. In addition, Attorney William Godfrey is present, representing the defendant Paul Younglove, and Mr. Younglove appears to be present with Mr. Godfrey. Good afternoon, everyone.
Good afternoon, Judge.
Good afternoon.
The court has been informed by Mr. Pratt the parties have reached their own agreement. Is that correct?
Yes, Judge.
Yes.
Wonderful. Who would like to place agreement on the record?
I will, Your Honor.
Please, Ms. Rourke.
Your Honor.
Wow. Jim, NPC, thank you so much. That is so generous. You sent me 65 Canadian dollars. I love you. Thank you so much. I love checking PPs. It's the best of all the best. Hi, Dr. Green Thumb. Amazing. That's amazing. Thank you so much. Oh my gosh. Amazing. Wow, what a day. And also, young love, these people look old. I just have to say it. I was thinking it the whole time. I'm a terrible person.
The parties have agreed to joint legal custody of Audrey with reasonable and liberal parenting time. Child support will be reserved until May of 2025 due to the child receiving Social Security in the amount of $1,800 per month and attending the middle college.
Can somebody explain to me that? Can somebody explain to me how a child would get $1,800 a month in Social Security? What is Social Security? If you don't know, I'm Canadian. And works differently around here. I don't know what Social Security is for a child. Is that for a disabled child? They said Social Security. But so $1,800 seems like a lot to me. Because like adults that are disabled get like half of that, which is terrible. But you would assume if it was death benefits reseller that these would be like, these are their parents, I think. And 1,800 might not be too much depending on care costs. That's a pretty good thing. Maybe the kid lost a parent, but these two are legally the parents right now. With what I've got in front of me, these are legally the parents. So maybe they lost a parent and then she found this new guy or something, and I don't know. Anyways, you're gonna hear he has quite the pensions going on. So let's continue.
Husband will maintain health insurance coverage for Audrey. Any uninsured medical expenses will be split 50-50 by the parties, and there is no ordinary medical amount. Mr. Younglove is awarded the marital home. Ms. Younglove will vacate the home by December 31st of 2024. Spousal support shall begin the first day of the first month after Ms. Younglove vacates the home, payable to her at a rate of $510 per month, and shall continue until April 30th of 2028. Support will be modifiable as to the amount, but non-modifiable as to the duration. There will not be a uniform spousal support order, as the parties prefer direct pay. Spousal support is barred as to Mr. Younglove. As far as vehicles, Mr. Younglove is awarded the 2007 Ford Fusion, the 2006 Mercedes, and the 2006 Lincoln. Ms. Younglove is awarded the 2014 Buick LaCrosse. Each party is awarded the bank accounts in their own name. Mr. Younglove is awarded the party's joint checking account ending in 1892. Ms. Younglove is awarded her own Vanguard non-retirement investment account, and she is also awarded 100% of the party's joint Fidelity investment account that ends in 9169. As for retirement investments, Ms. Younglove is awarded her IRA at NFS free and clear of any claims of Mr. Younglove. Mr. Younglove is awarded his Roth IRA account ending in 2877, free and clear of claims of Ms. Younglove. The rollover IRA.
These people have more savings accounts than I have digits in my bank account. Let's say that. It just continues on and on and on. This was a long-term marriage, though, as the judge is going to tell us in a minute. He is not happy that these people are getting divorced. As usual, you can never make Judge Bronlick happy. He's not happy if you stay married, and he's not happy if you get divorced. He's just not happy, Tin Man. That's his MO. Not happy. You keep getting political commercials? Ay, 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 ay. The fact that you're getting commercials is somewhat heartening, though. Loud. But yeah, we shouldn't have that.
At Fidelity, which ends in 9100, will be split equally between the parties. The IRA at Prudential Fortitude, that account ends in 2459, is an annuity. Mr. Younglove will begin drawing annually starting in October of 2024. Ms. Younglove will receive 50% of the net amount after federal and state taxes are withheld. That'll be payable directly to her from Mr. Younglove. She will also remain the primary beneficiary of that account, and the party's children will remain alternate or contingent beneficiaries. Mr. Younglove receives a Ford pension, which is currently in pay status. Ms. Younglove is the surviving spouse on that plan. She will receive 50% of the marital portion of the Ford pension. Mr. Younglove also receives a Boeing pension, which is also in pay status. All of that pension is marital, and Ms. Younglove.
Ford and Boeing? That sounds good. I mean, just to little old me, that sounds pretty good. All while he was married. So what I don't understand is the why she's being left on everything as like beneficiary. Is it like, you're too old, you're not allowed to fall in love again? Like, what if he falls in love with a lovely young lady who wants to just shower him with love and affection? It's sex that she's probably not giving it. For all, you know, just for her own good. Can't she be the new beneficiary? I'm always thinking of the new girl. Terrible, Paisley. Terrible.
Is listed as the surviving spouse. She'll receive 50% of the Boeing pension. Any and all quadros necessary will be prepared by Attorney Ann Pastrana, and the parties will split the cost for any quadros or costs assessed by plan administrators equally. Ms. Younglove will remain the primary beneficiary of Mr. Younglove's MetLife insurance policy, and the party's children will continue to be listed as alternate or contingent beneficiaries. Ms. Younglove does not have life insurance. There is an account receivable from the party's daughter, Clara. The parties, it'll be between them as to how that will be collected or repaid. The parties will divide their own personal property between them. Mr. Younglove will retain his fire.
Hold on, an accounts receivable. So is that the bank of dad? Is that what they're talking about? The bank of dad, basically? Are we doing elk impressions? Maybe? Do I look like an elk? Did I sound like an elk? Man. The bank of dad. Again, I just find it interesting that in their divorce agreement, they are stipulating that she will remain the payee. Like, what if he changes his mind? What if he wants a new lady? Wives can't win every battle.
Arms and tools, they'll divide the rest. Ms. Younglove will obtain her own health insurance coverage post-divorce at her own expense. Each party will pay their own attorney's fees. To equalize the property settlement in this manner, Mr. Younglove will pay to Ms. Younglove the sum of $10,000 on or before October 1st of 2024. And Ms. Younglove's maiden name of Amy may be restored to her if she so elects. And I believe that that is the entirety of the agreement.
Thank you, Ms. Worka. Mr. Godfrey, did Mr. Worka accurately state your client's agreement?
A couple additions, Judge, not major. My client, I will prepare a quitclaim deed for Ms. Younglove to sign dealing with the real estate, and I will get that to Ms. Worka to have her sign that. That can be exchanged after the $10,000 payment has been made. there will be a uniform child support order entered. It's just going to be zero on the child support amount with an asterisk indicating that it's based on the fact that the child is getting Social Security of $1,800, and the health insurance, my client would be responsible for obtaining that. And when my client has the coverage for the child, mother need not obtain it. And there's no annual ordinary medical. So for the program, it would just go zero for the annual medical amount. They would then split anything after 50-50 as they come due. And there was a couple of bills, credit cards of wife that will be going through the account ending in 1892 at Huntington Bank that my client is receiving. It's understood there's going to be a Costco bill coming through to be paid out of that, a Myers credit card of wife's coming through to be paid out.
Oh, can somebody pay my Costco bill? I don't even have a Costco card. The Bat Mom, does she look familiar? Does she? This whole vibe is 1972. That's exactly the vibe I'm getting here. Oh my God. I can't even imagine. You know when they give you like a shopping spree? Could you even do a shopping spree at Costco like that? Because I think it's too big. You couldn't do that run through and like get everything you wanted. It's just too big. But I can still dream. I can dream about winning a contest that they do not run.
Out of that, any credit card that the child Audrey and wife have would be coming out of that. And that was taken into account to get to the $10,000 cash figure. With those clarifications, Judge, I think that's it. One other thing, any cost by the plan administrator to implement any quadros would be shared equally by the parties as well. That's it, Judge.
All right, thank you, Mr. Godfrey. Ms. Work, are those clarifications acceptable?
Yes, Your Honor.
Okay. All right, to Mr. and Mrs. Younglove, will you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I affirm.
Thank you. The court notes that the jurisdictional proofs were taken on June 17th. So Ms. Worka, you can begin with Ms. Younglove and simply update the proofs terms confirming that she's not now pregnant, please.
Thank you, Your Honor. Ms. Younglove, can you state your name for the record, please?
Angela Marie Younglove.
Okay. And are you currently pregnant?
No.
And did you hear the term?
Oh, Lisa B, I like your twist. Let's talk about it for a second before these boring people get back to their boring rich-ass divorce. Also, Dixie Lords is catching up. Tell her, yay, in the chat. She won't hear this for another, 20 minutes, but that's awesome. Thank you for answering that question. Okay, so if the twist was that you could only buy 3 different items as much as you want, but only 3 different barcodes at the register, I would buy pallets of Coke. Pallets. All the pallets of Coca-Cola. All the meat. It would be, I think I would do 2 different kinds of meat and basically a full pallet of Coca-Cola. They don't sell the Colombian version at Costco, as far as I'm aware. Otherwise, I would go to that one. Although alcohol... Paisley, you sound weird. Alcohol, or, if I'm thinking about reselling, because that's what you'd literally do, you could buy vodka, or you could buy cigarettes and resell. And you work for Coca-Cola, Brian? I love Coca-Cola. I'm a Coca-Cola girl. But seriously, that's what I would do. I would buy, if you could only do 3 barcodes, I would do pop or a drink, because it lasts, right? I was thinking orange juice, like that Tropicana orange juice, but you can't store that and keep it long enough. It's going to go bad too fast. So, or butter. Or cheese. Oh my gosh. I might get a lot of cheese. Never mind. Oh, I have a lot to think about here. Again, a game show that's not real and doesn't exist. Remember, one barcode, so you could only do one kind of cheese. Maybe the shredded, maybe the big blocks. I don't know.
Of the settlement agreement that I placed on the record,
Yes,
and do you agree to those terms?
yes,
You understand them?
yes,
You agree to be bound by them?
yes,
And you understand that the property settlement cannot be changed?
yes,
You understand that you're waiving the right to a trial and that you could have done better, worse, or about the same?
yes,
Are you entering this agreement of your own free will?
yes,
Okay, and are you satisfied with my representation?
yes.
Thank you, Your Honor. I have nothing further.
Thank you, Ms. Worka. Mr. Godfrey, do you have any questions, first of all, for Ms. Younglove?
Just briefly, Ms. Younglove, did you report all of your liabilities and assets as part of the negotiation process?
Yes,
Nothing further, Judge.
Thank you. Questions for Mr. Younglove, please, Mr. Godfrey?
Yes, will you state your name for the record, please?
Paul William Younglove.
And you heard the settlement agreement that has been placed on the record here today?
Yes, I have.
Is that your agreement?
Yes, it is.
You're aware that you could have gone to trial with Judge Brownlee, you could have done better, you could have done the same or worse than what you have agreed to today, but you want the court to accept this as your final agreement.
I understand. I agree.
You understand that spousal support can be modifiable as to amount between now.
I just thought of something. It's possible that there's a frozen item that would be really good at Costco to get in bulk. Here's the thing. That's actually, honestly, pardon me, that is going to be one of the most difficult challenges you could ever do, because I challenge anybody to go into Costco and buy 3 things. If you have money. I can go into Costco with my sister or with somebody with a Costco card and not spend any money because I don't have any money. And it's very simple. Like, people, when they're like, oh man, I just spent $1,000 at Costco. And I'm just like, oh man, that can't happen. It just cannot happen. So, but I'm a bad influence. I like to go to Costco and influence people that seem to have enough money to buy things. I'm a bad person.
On April 30th of 2028, but not the duration. It could go
Correct.
up, it could go down in theory.
I understand.
Do you have any questions at all concerning this agreement?
No, I don't.
You're asking the court to approve it?
Yes, I am.
Have you revealed all of your assets and liabilities during the course of these negotiations?
Yes,
Are you satisfied with my representation of you in this matter?
I'm satisfied.
I have no further questions, Judge.
Thank you, Mr. Godfrey. Ms. Worka, do you have any questions of Mr. Younglove?
No, thank you, Your Honor.
Who will prepare the judgment?
I will, Judge.
Thank you, Ms. Worka. The court would be remiss if I didn't ask this question, Ms. Younglove. The court notes this is a long-term marriage, 39 years. Is there any chance of reconciliation?
no,
Right.
Oh, that's sad. 39-year marriage. Wait, they have a minor child? Is that child adopted? Did they adopt a disabled child? I should stop making fun of them. That's a long time. That's more than me. That's 3 years older than me. They've been married since 1985. Wow. I mean, the world has changed. But obviously, if there's a child that is getting child support paid, that is a child. So they must have had, ostensibly after 20 plus years of marriage, they adopted or took responsibility for a child who, oh, maybe the child's parent died. Now we're getting there. Oh, fuck. God, I'm such a dick. So probably the child's parent died, which is why they get the Social Security benefit, and they look after the child, which they adopted. That's what I'm guessing. Otherwise, the Social Security doesn't really make sense, but it's Social Security death benefit for a parent that died, and then they've adopted that child subsequently. That sort of tracks. Nobody looks happy on the screen today, I'll tell you that much. And Sean, you're right. And I've said this before. Most people that get divorced say they should have done it years and years ahead of time or earlier. They wish they had. Oftentimes they'll say they waited for the kids, but the kids are happy and happier after the divorce. But, everybody's different. But I would say that, I don't know. It's tough. It's tough. It's like 39 years. It's tough. Anyways, okay. So you receive Social Security benefits for your adopted niece whose bio mother died in 2020. Do you have to pay into Social Security in order to get the money? Also, Courtney, you're making me laugh. You tried to break your parents up for years and they were waiting for something else. Oh. What's funny is when I got older, I joked with my dad about when he and my mom finally divorced. I was like, you left me with her. What the fuck? He was like, sorry about that. I had to leave. I was like, yeah, no doubt.
Well, the court would like to thank and acknowledge Ms. LaPrade for her assistance in helping facilitate resolution of this matter. The court would also like to acknowledge and thank Ms. Work and Mr. Godfrey for helping the parties reach their own agreement. And Mr. and Ms. Younglove, without question, the best resolution is one in which you both participated, as you did this afternoon and previously, rather than have the court decide these matters. Based, however, on the testimony that's been presented today, as well as previously back in June 17th, as well as the complaint filed this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the object of matrimony has been destroyed. Unfortunately, there appears to be no chance of reconciliation. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. That will conclude here. Never can zoom out. Have a good rest of the afternoon.
Thank you, Judge.
Thank you, Judge.
You're welcome.
Insert that Apple song here. Do 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 do. I don't know how to do it. I can't do it. I can't play the song live. Also, yes, they're divorced, and now we move on to another one. These people not quite so agreeable with each other, I would say. Also, Katie9, that was nice. Your parents have been together since they were 12, married at 17, and now in their late 60s. That's commendable. I mean, that's sticking power, you know? Let's see. Judge Grumpy. Oh, I can still do both my parents' signatures really well. I mean, allegedly.
Is there a resolution on justice?
They're meeting with Josh on October 16th at 1:30.
October 16th at 1:30.
My stepmom's
Yeah,
really
yeah.
nice. And I think I was a
What's your
stepmom,
doctor's appointment?
a good stepmom, but
Oh, okay.
hi, Nico. I just wanted to check this for my yeah, okay. I'm a magician. I'm able to turn 12 minutes of court into 35 minutes.
Can you hear us?
Yes.
Yes.
Very good.
Yes.
For the record, this matter is before the court for pretrial conference. Subsequent the parties have engaged in mediation this afternoon. Present is Attorney Ronald French representing the plaintiff Philip Brock. Mr. Brock is present. In addition, Attorney Alex Goldman is present representing the defendant Jamie Brock, and Ms. Brock is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
Afternoon, Judge.
Have the parties made progress toward their own resolution this afternoon, Mr. French?
Yes, Your Honor, only on one item, however, and we're going to try to come back to mediation on October. Well, we are coming back on October 16th with Josh, and we're going to try to resolve the rest of the issues.
Okay, and that's at 1:30 on October 16th?
Yes, Your Honor.
What issues remain outstanding, Mr. French, just for the court's information?
Well, we have pretty much everything, Your Honor. Personal property, real property is the only thing that we've settled, so everything else is outstanding.
Okay, has discovery been concluded?
No, brother counsel and I have agreed to exchange a few more items. We're working very well together, Your Honor.
I have to say, I get weird Mormon vibes whenever I hear somebody refer to somebody like brother counsel or sister counsel. No offense to anybody who's Mormon, but I just get those vibes. I know it's a term. I know it's used. I know. My brain just says like, what underwear is he wearing?
Think there's going to be any problems with discovery, and I think brother counsel will attest to that.
I agree, Your Honor.
All right, what the court proposed, since this case is getting somewhat dated, any objection taken to proofs? The jurisdictional proofs this afternoon, the court will reserve all outstanding issues.
I have no objection.
No, I have no objection.
All right, Mr. and Mrs. Brock, we're going to take some brief testimony to establish jurisdiction. There's been a breakdown. Ms. Brock is not now pregnant, and the court will reserve all outstanding issues. It simply stops the court's clock, so to speak. Then we'll come send another pretrial conference after October 16th mediation with Mr. Walker. Mr. and Ms. Brock, can you both raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes, I do.
Thank you. Mr.
I have to say, honestly, what is going on with both of these people's lighting? I actually think that Jamie is appearing from an open casket that is half buried. Honestly, it is. How do they even get the light behind them like this? Also, yes, I will. I'll do that just for you, 007. There it is, in its spot. Seriously though, doesn't she look like she's in a coffin and she's just peeking out of the coffin and there's like dirt around it, and she sounds muffled, like she's buried a few feet down. Like, I swear to God. Also, yeah, I have a very odd sense of humor.
French, if you can be with Mr. Brock, please.
Yes. Could you state your full name for the record, please? Phil.
Philip Ernest Brock.
And did you come to me for this divorce a while ago, and is everything still remaining the same that it was back then, that there's been a breakdown in the marital relationship to where the bonds of matrimony cannot be maintained?
Correct.
And we met with well, let me back up. Do you know if Jamie Brock is pregnant at this time?
No, she's not.
Okay. And we did meet with.
These people hate each other. Wow, who cheated on who? What's going on here? There is anger. There is anger. They are so miserable. She actually looks like she wants to close the coffin. and send the dirt down. Oh gosh. Oh, he looks defeated.
With Josh, the mediator from the court, and we resolved one of the issues. Everything else is still outstanding. Is that correct?
Correct.
And you've lived in the county of Monroe 180 days prior to us filing, and 10 days, I'm sorry, in the state of Michigan for 180 days, and in this county for 10 days before we filed this complaint for divorce.
Correct.
Okay, I think that meets the jurisdictional requirements, Your Honor.
Thank you, Mr. French. Mr. Goldman, do you have any questions of Mr. Brock?
No, Your Honor.
Okay, any questions for Ms. Brock, please?
Yes. Jamie, is there any chance that you're pregnant today?
No.
Did you hear the questions that Mr. French asked Mr. Brock?
Yes.
Were those responses true to the best of your knowledge?
Yes.
Nothing further, Your Honor.
Are you being held hostage, Jamie? Do you need assistance? Is somebody standing over you? She is talking. I don't know that I've ever heard somebody sound more uncomfortable, and she's seriously like, what is going on? Paul, she wanted to transition to being a vampire and he wasn't into that. I love that. That's actually really good. I can't get over the fact that behind her looks like a bit of a cave. You know? Yeah, right. Like, blink twice.
Thank
Your
you, Mr.
Honor?
Goldman. Ms. French, do you have any questions, Ms. Brock?
I do not.
Okay,
Your Honor, the one issue that we need on the record, may I proceed with that?
if you wish.
I
Certainly.
do. I think Brother Counsel wants it on the record as well. The parties have sold the marital home and they're supposed to be closed on or about the 3rd of September. And we put it on the record with the mediator and we discussed it, and it's agreed to by both parties that once they sell the house, that the proceeds will be split 50-50. Whatever that number may be, it may be 40, it may be a little more, 40,000, it may be a little less, but whatever that number is, Brother Counsel and I will take a look at that, and it will be split, and it will be given to each party right then and there or shortly thereafter.
There is unsecured debt, is there not?
There is. Well, the house is going to be paid off with the proceeds.
Are they each getting 40,000? So that would be an 80,000 equity after they pay off the house. That's not bad. But Judge hates unsecured debt. It's actually like you've secured it to his balls. By Graham, honestly, it is literally like you secured the debt to his balls, and he personally has to carry that weight every single day. Even if he has nothing to do with it, that's how he acts about fucking unsecured debt. I'm not kidding.
Whatever is left is going to be split 50-50, Your Honor.
Understood, but is there not also unsecured debt, like credit card debt? The pretrial statement makes reference to there being unsecured debt.
There's
Yes,
quite
Your
a,
Honor, the parties own other assets that exceed the amount of unsecured debt. It shouldn't be an issue.
All right, I just was suggesting that sometimes you pay off the debt with those proceeds, and then you split the remaining balance, but I'll leave that to the parties and counsel. So is that correct, Mr. Goldman? You're agreeable that once the home closes, that the net proceeds will be shared equally between the two parties?
Yes, and more importantly, that the proceeds will be distributed shortly thereafter. We
Okay.
hadn't discussed this, but I would propose a specific time period.
We
there-
probably split it at the time of closing, can you not? So you get to tell the title company you want the proceeds split equally between the parties.
We can do that, Your Honor. There is one caveat that I'd like to add. There is approximately 15,000 in credit cards, and there's a camper payment. We would at least ask that 7,500 per party be reserved put in my trust account or brother counsel's trust account to cover those bills. If they don't negotiate them out, then they would be paid by both of the parties. I think that's fair.
Ooh, brother, ooh, what's that, brother? Ooh. Honestly, why does he keep saying it? It's freaking me out. Now I want pizza. I literally may walk my ass down to the store and get a pizza later. Brother, ooh. What's that, brother? Oh. I was remembering a conversation. Anyways, yeah. Judge is not happy about this. Judge is not happy about this. We all have our own little ex problems / lives, don't we? Excuse me. KC Carey's getting her t-shirt game on. I love that. Cindy just got off the phone with her ex. Missed everything. That's okay. Not really. We're just getting sort of going. And then, I live with my ex, so you know how it goes. Hi, Rose.
The camper's worth more than $15,000. I'm not sure that we need to handle unsecured debt that way.
I'm only talking about credit card debt, cars, stuff like that. My client tells me there's about 15,000 in credit card debt and somewhat. That's all we're talking about. Because those things are going to have to be negotiated out. And if all that money is spent, then it's we're behind the ball on it, Your Honor. We're not talking about the payments for the camper. There's 20,000 owed. My client was going to probably keep that and assume the debt on that, but there's credit card debt in excess of about 15,000. So we would ask
Presumably, credit card debt.
7,500.
Presumably, the credit card debt carries a significant rate of interest, correct?
That is correct, Your Honor. That's why we're asking.
That's the court's main inquiry. Shouldn't we pay off that credit card debt out of the top of the sale proceeds and then share the remaining difference equally, Mr. Goldman?
We are not in favor of that, Your Honor. We would like the proceeds of the home to be split immediately after
Right.
the closing.
If you can't reach agreement, the courts can order that the entire proceeds be held in a client trust account of one of the attorneys. And
We
if you
can
can't
do
reach
that
agreement
as
to pay off
well.
credit card debt, shame on the parties and shame on counsel for not encouraging that. It just makes common sense, Mr. Brown. I'm not sure which client's objection is. So if the parties cannot reach their own agreement, the court's ruling is that the proceeds be held in escrow in the client trust account until further order of the court or agreement of the parties. If you can work that through, fine. Absent agreement, then to remain in the client trust account of one of the attorneys.
That's fine with me, Your Honor. There is a caveat that I want to bring to the court's attention. In all fairness, brother counsel's client has nowhere to live. She's not living. She left the marital home about a year ago, and she wanted to get something that she could live into.
So she is in an underground coffin lair. That makes so much sense. It looks like an underground coffin lair. Also, where has she been living? Why isn't she living in the $15,000 or the $20,000 camper? Thank you, Katie 9, right? Why isn't she in the fucking camper? You know, Paisley of high school Paisley, who did all these like exercises on like how to budget. First of all, high school Paisley thought that Paisley was going to have a mortgage that's less than her rent. I don't know why we were so delusional, but we were. Anyways, and but high school Paisley would have been like, oh, I don't want to live in a camper. Paisley of today, nice camper, sounds like a plan, Stan. Like, beggars can't be choosers at this point. So where the fuck has she been living if they have a $20,000 camper or $20,000 plus? That sounds like a nice camper to me. Right?
So that she can have better visitation with the children. That's why brother counsel was arguing that we get it all out, but I'm in favor of putting it in a trust account. It could be in brother counsel's account, or I'll hold on to it. And if she needs X amount of dollars out of her half, as long as we have enough in there to cover those, at least the credit card debt, then I would be okay with that. And I think Brother Council can work that out if that is going to be your order.
And whatever the attorneys agree upon, that's fine. That's fine. I'm just suggesting let's get that debt taken care of because it's a high interest debt. If you can reach agreement in the interim, then fine.
Your Honor, I would prefer that we go with the previously discussed option where 7,500 get put in Mr. French's trust account. And then after that, the proceeds are immediately distributed.
But you can't reach agreement on it. So absent agreement, that's going to be held in the entire proceeds held in escrow until further order of the court. And the court without notice will see everyone after the October 16th, 1:30 continuing mediation with Mr. Walker. Perhaps the two counsel can confirm in the meantime, if they can reach some agreement, that's fine. You can certainly a stipulated order would be certainly approved by this court.
Your Honor,
discuss that further.
the parties intended to put that agreement on the record. I would ask that we state that agreement be ordered by the court today. Not requiring the parties to reach.
Oh, interesting. So he's fighting with the judge, and we know the judge, again, tethered by the balls to the debt, to the unsecured debt. I mean, it's practical. It has to be paid off. But, brother counsel threw you under the bus, Alex. Brother, he threw you under the bus.
Further agreement.
The court's not requiring the parties to reach a further
to
agreement. The parties will, I'm confused, Mr. Goldman. The parties will continue to mediate with Mr. Walker October 16th. The only agreement on is right now they've agreed to, I don't know what the agreement is. They've already sold the home. So that's really a past issue. I'm not sure what the agreement is.
That the proceeds be immediately distributed short of some security put in Mr. French's trust account.
I'm going to be talking with Mr. Walker. If you want to mediate this issue further, you can. Did you talk to Mr. Walker about that? Was he able to work through that issue with two of you?
Yes, I thought that was the agreement.
Your Honor, we're okay with holding 7,500 back of her funds in my trust account because that will cover the bills that I think we need to cover.
Okay, well, that's only half of the unsecured debt, though, correct?
Yes, but my client's he will be paying the other 7,500 because they're going to split it if they do that, if we can't work it out, and that will take her 75, and then we'll hold 75 for my client as well. That way, Jamie can get a place to live with the rest of that money. And if we can't work it out, Your Honor, we're going to have to come back and see you.
Okay, so again, I'm sorry I'm having difficult following. So out of the proceeds to sell the home, you've agreed that $7,500 will be paid toward the credit card debt off the top. The remaining difference will be shared equally. Is that correct?
Not be paid, be held until we further negotiate the rest of the deal.
Okay. All right. So $7,500 will be held in your client trust account, Mr. French. The remaining net amount will be shared equal between the parties.
Right.
All right. Okay. All right. Mr. Gomez, is that your understanding of the agreement then?
Yes, Your Honor.
All right. If that's the agreement of the parties, Mr. and Mrs. Brock, you're both agreeable with that from the net proceeds, $7,500 will be held back in the client trust account for further order of the court. The remaining balance will be immediately distributed equally.
Right. The
Mr. Brock, is that your understanding?
7,500. Yes, the 7,500 would come from Jamie's half, and my client will give me his half as well. But him and I can work that out.
You say it's coming from his half.
Right. She's going to do 75 on her half. He'll do 75 on his half to cover those bills if we can't negotiate those out. If we do negotiate those out and one party takes the debt, then that money would be given back to that party.
That wasn't my understanding. I thought it was 7,500 off the total net value.
That's only going to cover half the bills though, brother counsel.
There's going to be plenty of money to pay the bills afterwards.
Okay.
Your Honor, my client needs money as soon as possible to get into her own home to exercise parenting time. That's why I oppose to skimming this off or trying to resolve every issue that could be eventually dealt with at the end of this case. We had an agreement to split the proceeds of the home that just sold right now. The rest of the money can be sorted out at trial.
Mr. French?
That 7,500 that we talked about would be fine, Your Honor. I'll deal with my client on the rest if we have to. We may not have to.
Okay. So I'm still not real clear if we have an understanding here. Are we in the same page?
Yeah, the home, out of the net proceeds of the home sale, $7,500 will be immediately put in Mr. French's trust account. The remaining proceeds will be immediately distributed to the parties equally.
Yes, that's
7,500 will be taken off the top. Obviously, each party has a half interest in that 7,500. That'll be held in the client.
Why is this so confusing? What is going on? Is she in a race car bed? Like, what is going on in this situation? Did she leave the children? I have so many questions. She's sitting. Is that a car? If it's a car, where's the fucking camera? Like, it's a car bed in a cave. Oh, you guys. Can't they just split it 50-50, right? Well, that's what they agreed to, but the judge has that fucking unsecured debt to be paid, and the other lawyer's like, Judge, no.
And trust account, the remaining difference will be shared equally, split, correct?
Yes.
Correct, Mr. Goldman?
Yes, Your Honor.
All right, and Mr. and Mrs. Brock, do you both understand that?
Yes.
Mr. Brock?
But I have a question. If that's her half, why is it coming off the top and then it's split? Why isn't it coming off for her half?
Your Honor, the agreement that we walked in with from mediation was not to address the debt at all. The agreement was just for the home proceeds to be split, and then we started talking about debt, which is not what the parties had agreed coming from mediation.
Yeah, Your Honor, we did not think about the debt, the unsecured debt, as you mentioned, that it's at a high interest rate. At this point, I believe my client's paying most of the credit card debt. I don't believe that she's paying any. I think we should probably go back to the 7,500 for both parties, or 15,000 off the top and then split, and then it's equal, and we'll cover the credit card unsecured debt. That's what we really should do. That's the question from my client.
Maybe we need to go back.
Oh my god. Yeah, my chest is blushing. I can't be sunburnt. I did not go outside today. I didn't go outside yesterday either. It is a filter that I use to make me not look like a vampire. Whoa. It's like Jamie's picking up a drive-through order. This is the angle. It's a drive-through angle. That's the angle. But anyways, I appreciate the concern, but I am not sunburnt, just using a filter that makes me look somewhat sunburned. I guess it accentuates the more red of my skin, but and I guess, I mean, I could pass for that, but I swear to God, it's pouring rain outside and I didn't go outside today, so I promise. I would tell you, I do sit in the sun sometimes, but not today.
Back in front of Mr. Walker. We were spending time with Mr. Walker. We emerged from mediation with an agreement, and then that agreement was altered in a way that I don't agree with.
How much do you anticipate to be the net proceeds from the sale of the home?
Was it 269, Mr. Brock?
250, I owe about 170. There's some hidden fees in there, like transfer title fees and stuff. So there's an estimate around 80,000. It all depends on when we close and the transfer title fees. They didn't have all that on the record.
So the net proceeds are anticipated to be 80,000. Is that understanding, Mr. Goldman, Mr. French?
That sounds about right.
Yes.
Cheap houses, I'm so jealous. I could afford that kind of house payment too.
So even if we pay the credit card debt of 15,000, which makes imminent sense because it's reduced the cost of both parties, there'll still be 65,000 to share. How much does Miss Brock need? Does she need more than $30,000 to get a place to live?
I'm not sure the exact number. I just wanted her to have as much at her disposal as soon as possible.
Is her plan to buy a house or is she gonna rent a house?
Probably gonna have to rent, Your Honor.
Significant. It seems that the court make imminent sense. Let's get rid of the debt unless one of the parties are planning to file bankruptcy. It makes sense to get rid of that debt as soon as possible, that high interest debt. And then even at 15,000, you'd have 65,000. Each party would split about $32,500. It should be sufficient to get Miss Brock back on her feet, so she's got a place where she can exercise parenting time.
Yeah, we agree.
That's just the court's thoughts, but I'll have to put you back. Mr. Walker, are you still available? I don't know if he's been able to hear this conversation.
I'm here, Your Honor. Yes.
Jamie, does that sound okay to you? The entire debt comes off the top and you get $32,000 in the next month?
Sure.
Bill, does that sound good to you as well?
Sounds good to me.
Okay. I think that's what we should do then, Your Honor.
It makes imminent sense. Again, obviously, we're talking about approximate figures. We're talking about approximately 80,000 in net proceeds, approximately 15,000 unsecured debt, approximately 32, the balance of 65,000, approximately 32.5. It could be give or take a few $100s either way. But if Miss Brock is comfortable with that, Miss Brock, you're comfortable with that in terms of getting a place to stay so you can exercise parenting time? Miss Brock?
Was that? I'm sorry, my phone went off.
Sorry.
Jamie, do you agree with what we just discussed, which is that the entire credit card debt will come off the top of the proceeds from the home sale? And we estimate that you'll get around $32,500 from the proceeds of the home.
Sure.
All right. For the record, she indicated sure, so she obviously understands and is agreeable with it. So I don't know if you need to prepare an order to that effect, but at least that agreement is noted on the record. So the party shall schedule a closing as soon as possible. I'm sure the title company can do all this. You give the title company the list of the credit card companies and the payoffs, and they can pay that directly out of the sale proceeds, with the remaining balance being shared equally between the two parties.
Sounds good to me. Thank you, Your Honor.
All right, the court will mail out notice and the
Who
parties
gets
will
to rack
meet
up
with
the
Mr.
whole
Walker.
new credit cards, all the new credit cards, or all the paid off credit cards after that? Although you'd think that they would close them, but they probably won't. Seriously, what is going on with her? What a crazy thing. It is smart to pay off the credit cards, but here's what I would say. What happens if it turns out that she didn't use any of the credit cards? Like, for example, when I got divorced, my ex-husband popped out of the blue with all this credit card debt, and I was like, what the fuck? I didn't know you had credit cards like that. What? You make a lot of money. Where's all your money? He was like, he didn't really explain that. And then he wanted us to split that debt. Now, I understand that it's marital debt, but we never ever shared bank accounts, and I paid for my own side of things, and he paid for his own side of things, and I'm just saying it was a surprise to me. So, if I was negotiating in mediation, I would probably try and negotiate that coming off his side, not my side. But anyways, just the pro tip. And I never had any credit cards. And I was just like, what? I literally was like, did he have a drug problem? Or did he have a fucking, like, I don't know what he had. I don't know. But it wasn't money. It was just debt that I didn't know about. Which is scary. Scary!
October 16th at 1:30, and that's subsequently appear before this court for a final pretrial conference.
Thank you, everybody.
Thank you, Your Honor.
I'll be available on that day, Nancy. Be available on that date?
Yes.
All right, that will, if there's nothing further, that will conclude this matter. Everyone can zoom out. Have a good rest of the afternoon.
They zoomed out, they zoomed, we zigged, we zagged. What kind of room do we think that she was in? I wish I was in this room. Making cookies and ice cream in my Ninja Creamy that I own in my dreams. I did put that. I put a lot of fun stuff on my Amazon wish list. If you ever wanted just a laugh, please do go check it out. I put a lot of fun things on there. Also, tomorrow is Tuesday, and I'll be back. I'll be back at it again with the white vans, hanging out with you guys. So, Loud, you're going to work. Appreciate that. We did thank you for the super chats and for the gifted memberships. We didn't really push it today. We were good. You know, YouTube Daddy gave us a scare yesterday with the gift memberships, but it looks like we good. Yeah. Anyways, the lesson here is know who you're marrying, know who you're divorcing, and better yet, know who your judge will be, because that's the most important thing, baby. You may get fucked. Did you see that judge just fucked up those lawyers' agreement? That's what happened there. They both came in, brother counsel, brother, ooh, brother, ooh, what's that, brother? But they were all happy. And then, no. Judge was like, are you happy? You're happy in my court? No. Absolutely not. Give me some tears of children to sprinkle on everybody. Hi, Ed. I exaggerate a little bit, but seriously, I would love to talk with Judge Braun, like, outside of court, at Costco, perhaps. I guarantee he goes to Costco with his wife on the weekend. I am also getting a gluten-free vibe. Take that as you may. Take that as you may, but I'm getting a gluten-free vibe from the judge. It's just, I gotta say it, Donald. Had to say it. I feel it. I feel it in my fingers. I feel it in my toes. He ain't eating bread anymore, oh no. Seriously. Okay, that's enough of that. I'm gonna stop singing and get going for the evening, but I wanted to say thank you so much for being here. Remember that I love you, I am proud of you, and I will see you in the next video. Bye! Now where's that button that I made? Shit. Fuck, I wish I was kidding. Bye, guys.
Ways down and